Hello, you're watching Hornbill TV's Explanatory. India's criminal justice system administers punishments based on the Indian Penal Code. The nature of penalties varies depending on the gravity of the offence and can be broadly categorized into imprisonment, fines and capital punishment. But a lot will change coming July 1st, 2024, as the colonial era laws will be replaced by the three new laws that were introduced last year in the Parliament. In today's explanatory, we will explore the three criminal laws: the Bharatiya Nyaya Second Sanhita, Bharatiya Nagrik Suraksha Second Sanhita and the Bharatiya Sakshya. On December 12, 2023, the government withdrew three bills which were to replace the British-era criminal bills and brought three new legislations in the Lok Sabha incorporating the changes recommended by the Parliamentary Standing Committee. The three new bills were the Bharatiya Nyaya Second Sanhita 2023, the Bharatiya Nagrik Suraksha Second Sanhita 2023 and the Bharatiya Sakshya Bill 2023. The IPC will be replaced by the Bharatiya Nyaya Second Sanhita Bill 2023. The CRPC, or the Criminal Procedure Conduct of 1973, will be replaced by the Bharatiya Nagrik Suraksha Second Sanhita 2023, whereas the Indian Evidence Act of 1872 will be replaced by the Bharatiya Sakshya Bill 2023. Union Home Minister Amit Shah introduced these legislations in the Lok Sabha. Moving the bills, Mr. Shah said the parliamentary panel had made several suggestions on the already introduced bills. Following their introduction in August, they were referred to a 31-member parliamentary standing committee headed by BJP MP Brij Lal for review. After consulting experts and stakeholders, the panel adopted its report on the bills on November 7th, with opposition MPs pointing out several errors and recommending more than 50 changes. In their dissent notes, the opposition MPs flagged the lack of diversity in the experts consulted, questioned the haste with which the new laws were being introduced, and highlighted that they are largely a copy-paste of the existing laws. Union Home Minister Amit Shah said that the three new criminal law bills will bring comprehensive changes in the criminal justice system in India and free the citizens from the colonial era mindset. He said that the old laws were meant only to protect the British interests and their focus was to punish and not deliver justice. But the new laws will be future-proof with a focus on justice delivery and not just punishment, Shah added. Shah said the timeline and financial challenges had been a big barrier to securing justice in the country. Justice is not delivered timely, tarik pe tarik milti hai, police blame courts and government courts blame police. The government holds the police and judiciary responsible. Everyone keeps shifting the blame on each other, he said. For the poor, the biggest challenge to get justice is finance. Now we have made many things clear in the new laws. There will be no lingering on, he said. Now talking more about these three new bills, there are some major introductions in the new criminal bills which will be coming into effect soon. Now, in the Bharatiya Nyaya Second Sanhita Bill 2023 that will replace the Indian Penal Code of 1862, touted as one of the most significant reforms to the Indian Penal Code, BNS repealed sedition as an offence. While true on paper, the Ministry of Home Affairs has simply removed the word sedition from the law, formerly Section 124A of the IPC, and replaced it with a much more vague and broad nomenclature in the BNS through Clause 150 titled Acts Endangering Sovereignty, Unity and Integrity of India. The clause criminalizes acts endangering the sovereignty, unity and integrity of India, which include using electronic communications to excite armed rebellion, subversive activities, secession, separatism, or to endanger India's unity, sovereignty and integrity. Actions similar to sedition will be penalized, but with a wider scope and application due to its vagueness, which will have catastrophic effects on free speech, dissent and journalistic freedom. What's more stern about this is that punishment under Clause 150 mandates imprisonment under all circumstances, unlike Section 124A, under which the penalty could be limited to a fine. Further, possessing property derived from or through a terrorist act is punishable only if it is held knowingly. Similarly, harboring a terrorist is punishable if it is done both voluntarily and knowingly. The offence of recruiting and training persons to engage in terrorist acts has been introduced as well, mirroring Sections 18A and 18B of the UAPA. The offence is punishable with death or imprisonment for life. Those who conspire, abet, incite or facilitate the commission of a terrorist act could face imprisonment ranging from 5 years to life. Another important facet is the punishment for mob lynching. The original bill made mob lynching and hate crime a separate category of murder for the first time. The offence dealt with cases where murder is committed by 5 or more persons acting in concert with one another on grounds of race, caste or community, sex, place of birth, language, personal belief or any other ground. However, it was criticized by the panel for prescribing a lesser minimum sentence of imprisonment of 7 years as opposed to the offence of murder, where the minimum sentence is imprisonment for life. Taking the critique into consideration, the revised bill has removed the minimum punishment of 7 years and now penalizes mob lynching at par with murder. Two crucial recommendations of the panel to include a gender-neutral provision criminalizing adultery and a clause that criminalizes non-consensual sex between men, women, trans persons and acts of bestiality have been left out in the revised bill. In 2018, a constitution bench of the Supreme Court unanimously decriminalized adultery for being discriminatory and infringing upon a woman's autonomy. Now, in the Bharatiya Nagrik Suraksha Sanhita 2023 that will replace the CRPC of 1973, community service has been defined. The original bill introduced the concept of community service as a form of punishment for petty offences such as an attempt to commit suicide, public servants unlawfully engaged in trade, theft of property less than Rs 5,000, public intoxication and defamation in line with the panel's recommendations. This punishment has now been defined under Section 23 of the revised bill. Community service is work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. Moreover, a magistrate of the first or second class has been specifically empowered to impose this punishment to encourage a more reparative approach to minor crimes. The revised bill has overlooked the concerns of the panel regarding a provision in the earlier version that allowed police custody beyond the initial 15 days of arrest. Section 187 Subclause 3 of the bill, which corresponds to Section 167(2)(a) of the CRPC, does not contain the phrase otherwise than in the custody of the police, implying that the prescribed 15-day period of police custody can now be an aggregate of shorter periods of custody sought over the entire period of investigation, lasting 60 or 90 days, depending on the nature of the offence. The revised bill has overlooked the concerns of the panel regarding a provision in the earlier version that allowed police custody beyond the initial 15 days of arrest. Section 187(3) of the bill, which corresponds to Section 167(2)(a) of the CRPC, does not contain the phrase otherwise than in the custody of the police, implying that the prescribed 15-day period of police custody can now be an aggregate of shorter periods of custody sought over the entire period of investigation. Section 172 of the original bill allowed the police to detain persons who do not conform to any directions issued by the police to prevent the commission of cognizable offence. However, an ambiguity in the provision permitted the preventive detention to continue until the person is produced before a magistrate or the occasion is past. The panel recommended that a strict timeline be specified to ensure that there is no abuse of power by the police. Accordingly, under the revised bill, the detained person must now be produced before the magistrate or released in petty cases within 24 hours. Now, in the Bharatiya Sakshya Bill 2023 that will replace the Indian Evidence Act of 1872, Section 61 of the original bill allowed the admissibility of electronic evidence by underscoring that an electronic record shall have the same legal effect as a paper record. However, there was no requirement for a certificate under Section 63, corresponding to the requirement of a certificate under Section 65B of the Indian Evidence Act. This provision has now been revised to state that the admissibility of an electronic record is subject to Section 63. These three new criminal laws look to provide a fresh perspective to the old colonial criminal laws with new additions and subtractions. But there have been voices in the opposition stating that the new laws would make India into a police state. On July 1st, these three new criminal laws will be enforceable, so only time will tell if the courts, lawyers, defendants, people associated with law will be able to cope with the new laws. For more explainaries like this, keep watching Hornbill TV. Goodbye.